docket, some of which have fallen off the court's docket because of a withdraw or edit to the current motion for relief from an order filed by E-Box of Tennessee, LLC. I see Mr. Bava in the courtroom.
Yes, Your Honor.
Mr. Gino is on the screen. I see Mr. Cotton, and then I see Ms. Rochat. And are there any other parties for this case in the courtroom? All right, Mr. Cotton is at the podium, so I'm going to take up his matter first. His is a motion to dismiss the case for failure to file tax returns. Good morning, Mr. Cotton.
Good morning, Your Honor. There's been a response to that. I understand that some tax returns are filed. I have not gotten confirmation of that from the IRS, and apparently others are in the process of being filed. And we will agree to whatever time is that the debtor needs to finalize that process. We're not going to
Press.
We're not going to press that while they're working on what's apparently some pretty complex tax matters.
Okay. Mr. Gino, the notes that I had to myself is that we were going to continue these matters to August 2nd. Is that still your understanding, August 2nd at noon?
Yes, ma'am. Good morning, Your Honor. Craig Gino for the debtor. I think that's when we continued the hearing on the disclosure statement, Your Honor, to give us a chance to get these returns filed. And I'm advised that all of the trust fund tax returns have been filed, and then we're working on the income tax returns. But my understanding was the same as the court. We would take these up at noon on August 2nd, along with the disclosure statement.
All right, Mr. Gino, I hate to do this to you, but the audio was not working, so you may have to repeat yourself.
I'll get close. Is that any better, Your Honor?
We can hear you now. We fixed the issue, but I only caught the end of your statements.
I was saying that my understanding is the same as the court, that we were going to continue the IRS motion to August 2, when the disclosure statement is again set for hearing, to give us an opportunity to finish up these returns. I am advised that the trust fund tax returns have all been filed, and we're working on the income tax returns, keeping in mind the court's suggestion that we may be able to have take advantage of the probate estate's stepped up basis, and we're certainly taking that into consideration.
Okay, so I'm going to show matter 27 and 41 as continued to August 2nd at noon, and I know both parties will continue to hopefully resolve that objection or motion. Also on the court's docket, which I think I'll take up first because it's the potentially the easier one, is proceeding number 29, which is the objection to the motion that was filed. This objection was filed by K&S TE LLC. This is one in which Mr. Forrester represents the purchaser of substantially all of the debtor's assets, and my understanding is that there was an agreement that was worked out with Mr. Fava's client, and this was withdrawn, and so I'm going to show that as withdrawn, and the order will be prepared by Mr. Forrester.
Yes, ma'am. Thank you, Your Honor.
All right, Mr. Fava, this is your motion for relief from the automatic stay. Also with that is, believe that there was maybe an amendment to that, although it did not make it onto my calendar, and then there were 2 answers filed by E-Box LLC. And what is not part of the court's record is there was, the court had a conference yesterday to get an update because of the flurry of withdrawals and motions or edits to motions that occurred Tuesday evening, I believe, or Monday evening, and so I wanted to have an update as to what I really needed to prepare for today. Ask the parties whether or not we were going to proceed, and I think I'm just going to let the parties initially, just for the record, tell the court what has occurred to this moment, and then, just briefly, and then we're gonna let Mr. Gino bring up his procedural issue, and then that's probably what we're gonna take up first. So you have the floor, Mr. Fava.
Yes, ma'am. Thank you, Your Honor. And this is, as the court says, is my motion for relief from the order under Rule 60D. Now, we want the court and the record to be clear as to how we got here. My client is E-Box of Tennessee, which was approved by this court as the stalking horse bidder. There was an asset purchase agreement that was entered into between the debtor and my client, and the relevant section of the asset purchase agreement that we're having an issue with at this point is section 3.3, which states that the breakup fee would be equal to 2% of the sale price. And the sale price is lowercase s, lowercase p sale price. There is a defined term in the asset purchase agreement, which is purchase price. It's capital P, purchase price. And that is the stalking horse bid of 6.7 million plus. So obviously, just reading the asset purchase agreement, we're dealing with two different terms. Paragraph 3.2 of the asset purchase agreement refers to capital P purchase price, and then paragraph 3.3 goes into the breakup fee, which would be 2% of the sale price, lowercase s, lowercase p, sale price. So just looking at those two paragraphs alone, we're not talking about the same, when someone reads the asset purchase agreement, we're not talking about the same term. Purchase price and sale price are two different terms. So my client entered into the asset purchase agreement. The court approved the asset purchase agreement by order entered on at docket number 164, and the notice of stalking horse bid was entered on docket number 134. So my clients were under the impression that, based on the asset purchase agreement, the sale price would be the sale price that was ultimately agreed to, the winning bid, the ultimate price that the asset sold for. Excuse me. And that, as I said, is even strengthened by the fact that those two paragraphs are talking about completely two different terms. Now, my client did not know that there was going to be an attempt by the debtor to pay the lower amount, the 2% of the stalking horse bid, until they were sent wiring instructions. And at that point, E-Box of Tennessee said, hold on, that's not what the asset purchase agreement says. And their response, the response that they received was, well, that's what the final order says, so that's what we're going to pay you. And this was at the end of April. Well, then around the beginning of May, that's when E-Box of Tennessee contacted me. And so I looked through the docket, and it's, as Your Honor knows, it's a fairly lengthy docket. And I saw that basically how we got to this point was everything in the docket refers to the asset purchase agreement. And it states, in the asset purchase agreement states what I previously said. Until this final order was entered, which was prepared by Mr. Gino and submitted to the court. And the final order, all of a sudden, we get a shift from the 2% of the sale price to paragraph 42 states that the breakup fee will be 2% of the stalking horse bid. So we're talking about two different calculations, and that's the issue that we have now. And so when my client contacted me, I thought, well, certainly there's some logical explanation to this. It went from the definition in the asset purchase agreement to the final order. So I reached out to Mr. Gino on May 11th and sent an email to Mr. Gino and simply said, Mr. Gino, Craig, I've been contacted by E-Box of Tennessee. I would like to discuss this with you if you have a chance to see what the explanation is for how the number shifted from what my client thought it was to what was in the final order. And that email was ignored. I never received a response to it. So then on May 13th, I sent another email, and it was more detailed as far as what my understanding of the facts were. And I requested Mr. Gino to get in touch with me again. And because the previous email was ignored, I gave him, I said, I would like a response to this email by May 15th, or I'll be filing a motion under Rule 60B to request relief from the order. And within an hour, Mr. Gino replied and said, no, go ahead with your motion. Go ahead with your motion, Will, so we can tee this up as soon as possible. Regards, Craig.
Did your client receive at least the 2% based on the stalking horse bid?
Not yet. They refused it. They did, because they didn't want to waive anything.
Right. Okay.
And so I did what Mr. Gino suggested and went ahead and filed my motion to, as Mr. Gino said, tee this up as soon as possible. And now we're teed up today on the motion. And 2 days ago, late in the afternoon, Mr. Gino raises the issue of procedurally we can't go forward now because he claims that we should have to file an adversary proceeding. Well, we're okay with that. There's no urgency to get the money. My clients aren't needing the money to pay the light bill, so there's no urgency, and I'm 100% okay with getting an adversary proceeding filed. But I think we do need some relief from the final order because, as Mr. Gino says in his response, this is a breach of contract now. Well, if I file an adversary proceeding under breach of contract, their first defense is going to be, well, the final order says this. So, and as far as relief under Rule 60B, we have mistake, inadvertence, and that's initially where I thought we were. It was a mistake or inadvertence. The more pushback I get, the more I'm leaning towards it might be not mistake or inadvertence, but that's something we can flesh out in the adversary proceeding if we end up in that posture. But the problem that we will have is because Mr. Gino presented this 40+ paragraph order to Your Honor that included the actual numbers, their defense is going to be, well, the judge has already ruled on this. And so if Your Honor is going to move this over into an adversary proceeding, we would request that we at least get relief from that one paragraph pending resolution of the adversary proceeding.
I've got an idea, but I think I want to hear from Mr. Gino before I show my cards. So I hear your concern, and Mr. Gino, I'd be pleased to hear from you.
Good morning, Your Honor. Craig Gino for the debtor and the respondent here. This Mr. Favor brought up by ignoring his demand. I feel compelled to respond to that. May 11th was a Thursday. That morning, I was at my children's awards day ceremony. That afternoon, I traveled to Hattiesburg, Mississippi for a confirmation hearing before Judge Sampson. And the next day, I was in court. That was 12th, and it was a Friday. I guess he expected me to respond within 24 hours, but I did receive the notice from him on the 13th, and I responded promptly when I was back in the office, even though that was a Saturday. So I hope that resolved that issue. When Mr. Fava, without notice to me, settled up on the setting aside of the sale order feature of his 60B motion Monday evening, it occurred to me that this really is more of a breach of contract action now than it is anything else. If he still wants relief from that order, because we're still going to advance that as a defense, that could be count one of his complaint if that's the route that he wants to go. My objection in continuing this as a contested matter and not as an adversary proceeding is he, in essence, is seeking a judgment for money. And I don't think you can get there from here unless you file an adversary proceeding. So if he wants to have count one to be relieved from the order court entered, that's long since become final and not appealable, and all those sale issues are moot, we contend, then that's certainly acceptable to me. I'm sure that's what he'll do. And then count two could be a simple breach of contract claim, because my client's testimony all along will be, we didn't intend to offer the stalking horse bidder anything other than 2% of the sale price in the stalking horse APA, not to give him an unlimited, because we didn't know what the sale price, ultimate purchase price is going to be, an unlimited blank check to increase that as the sale process went along, even though he didn't do any further work or due diligence once the sale process actually started. So that's where I think we are. I'm happy to enter into an agreed order converting the contested matter to an adversary proceeding. It'll need to have a complaint filed. And if he wants count one or count two, for that matter, to be relief from the order, because the order has become final and non-appealable, then that's certainly acceptable to me. That's what I think would make sense, because he didn't want to give up that claim, and I don't want to give up my defense to it. But I think the real step that needs to be in an adversary proceeding is his client claims a construction of the stalking horse asset purchase agreement one way. We contend it's another way. That sounds like a breach of contract claim to me. That's why I raised that issue, Your Honor, and didn't want to go litigate a contested matter when it might give the claimant a second bite at the apple to file an adversary proceeding later. Thank you, Your Honor.
Thank you. Any comments from the U.S. Trustee's office?
No, Your Honor, we're taking no position.
Okay. I want to put you on the spot for a second and ask if the U.S. Trustee's office would have objected to a 2% on the stalking horse versus the actual sale, or would you have still sat back and not participated?
There would have been no objection.
Okay. So I think I want to leave the door open for you, Mr. Fava, and what I want to do is I want you to go ahead and file your adversary proceeding, because I would hate to be appealed on a procedural issue that maybe I got wrong. And so what I want to do is have that adversary proceeding filed. I will keep the current motion on the court's docket, and what I will do, depending on the pleading and how it is pled, my thought initially was I would potentially just have them consolidated going forward, and so that still leaves the door open if it is truly a Rule 60 issue versus is it a contractual issue, and so it doesn't close the door on either argument or anybody's potential defenses. And so if you will proceed forward with filing your adversary proceeding, we will watch for that. And what I want to do is I will probably just continue today's matters. I'll put it to the August 2nd at noon calendar. And then to the extent you get that adversary filed, and let's say it's close to that date and we don't have the status conference quite set, or it would be too soon, I may just automatically adjust that date so that you don't have to appear unnecessarily. But I want to leave the door open for both parties.
Yes, ma'am, thank you, and I will have the adversary proceeding filed well before August 2nd,
Okay,
I promise. And,
wonderful. And then it would be wonderful if I can consolidate everything going forward on August 2nd. And I do want to pose this question to you too, and maybe this is a Mr. Gino question. If, I guess August 2nd would be the disclosure hearing, not necessarily confirmation, but I see this potentially as, okay, you get to confirmation, and is there gonna be an objection by Mr. Fava's client potentially because that money hasn't been earmarked or resolved yet? And maybe you can work that out. I'm positive you can work that out in your head, but I just want to pose that because I don't know if the adversary is going to move quite as quickly or as quickly as needed, depending on when you want to try to get confirmation in the case.
Yes, Pam, my initial thought, Your Honor, is we would just simply, if we get to confirmation before the adversary is tried, we would simply carve out $100,000, however much it is, put that in a separate interest-bearing escrow account and wait for your decision on the adversary before we do anything with it. That won't materially affect distributions to the unsecured creditor class, and it won't affect distributions to, there really aren't any secured creditors left that would have any claim to that, the funds that are on hand. And it wouldn't affect administrative or priority because they have a higher priority and have to be paid in full in cash. It would dilute the unsecured payments a little bit, but a de minimis amount. It really wouldn't make that much different. We could go ahead and make the distributions to the unsecured creditors and hold that back in reserve in an escrow if we don't have the adversary decision by the time we get to confirmation.
Okay, wonderful. I just wanted to plant the seed, and it sounds like you have a good plan moving forward. So I'll show the remaining 3 matters, which is matter number 28, 42, and 45 as continued to August 2nd at noon, and then I'll look for that adversary proceeding, and we'll try to use the same date to the extent you get that filed quickly.
Your Honor, can I mention one more thing?
Yes.
That could be a procedural issue that comes up down the road. Rule 60 does state upon motion. So.
That's why I want to leave the motion still on the docket.
Thank you.
Yeah.
I thought you had it figured out.
I just don't want it all on the docket. All right, so all matters are continued to August 2nd, and then we'll look for that adversary, and then depending on the timing, we may adjust the dates for just these proceedings. Thank you very much, and Mr. Gino, good to see you. Mr. Gino, I will note that I noticed that your cup says Blankler Brown.
It does. That was I won a bet with Mr. Curry, so he awarded me a cup.
All right, well, you're advertising for him. So good to see you, and good luck with the rest of this case.
Very much, Your Honor. Thanks for letting me appear by video.